again in the same case between InterDigital and Oppo. And here the question was more specific. It's about confidentiality again, but more specific angle, whether a disclosure of specific agreements of the parties should be ordered here or not. Before we go into the specificalities here, just as a background to be able to understand the case a bit better, one of the defenses that Oppo had raised here was the exhaustion argument. They basically said that there is no need to take a license, and of course there is no infringement, so there should be also no injunction, because the patents that are asserted here is more or less licensed by an agreement between InterDigital and Qualcomm. Why? Because Oppo buys the chipsets for its smartphones from Qualcomm, which is already licensed by InterDigital, and therefore it is authorized to sell its chipsets which are licensed. So the patent rights which InterDigital asserts here are exhausted already through the fact that Oppo buys the chipsets from Qualcomm, and Qualcomm has a license with InterDigital. This was here the main argument, which of course is, if you extend it, goes further to the argument that all the relevant patents here are exhausted at the chipset level and not at the end device level. InterDigital, of course, countered that. They argued that the Qualcomm agreement that they had signed was no longer active. It had expired, and it referred to chipsets only and not to handsets, for example, and it covered also previous standard generations. So this was the background of the discussion here, which led to the specific requests of the parties. The first main block was exactly this this argument that there has been patent exhaustion here, and therefore there is no need to license and no need to grant an injunction. The second motivation behind these requests here was solely the front assessment. So what terms are actually front? This was of course also a part which was disputed here. There were offers and counter offers by the parties exchanged at some point in time. So for deciding also whether these offers and counter offers, the terms were front, this the parties argued that they needed access to this specific four agreements. So on the one hand, InterDigital requested access to the agreements of Oppo with Qualcomm itself. So Oppo had also an agreement signed with Qualcomm, and it also InterDigital asked for access to agreements signed by Oppo with all other SEP owners. This was limited then afterwards only to two agreements, one agreement between Oppo and Ericsson and another agreement between Oppo and Orange. So this was InterDigital's ask. Oppo, on the other hand, asked the court to order InterDigital to disclose its agreement with Qualcomm, which at least in Oppo's eyes would be important when it comes to the exhaustion argument. So here the court needed to decide on these two requests, and it looked at the standard that should be applicable to answer these questions, and looked back at a decision of the Supreme Court of India in the case called Sethi versus Kapoor. And here basically the court said that as a rule for ordering disclosure of documents in the proceedings, it is sufficient that the documents would be relevant for the purpose of throwing light on the matter in controversy. So if we look at that, it seems not to be a very, very high threshold. So if there is some type of relations or some type of use of the documents for basically clarifying the facts of the case, which are disputed between the parties, then usually you would have a good argument to ask that this document will be disclosed in the proceedings. And this was made clear by the court here by adding that it's not required regularly that the document is admissible in evidence. So it can be any type of document that can help the court get a better understanding of the case and explain the case, the facts of the case in a better way. So this is the standard that the court applied here. And then it answered one question after the other. The first one, must InterDigital disclose this agreement with Qualcomm in the proceedings? And the court was clear here to say yes, they should. Why? Because the court found that this agreement is relevant for both issues that we discussed already, meaning both for the exhaustion argument and also for the front assessment. For example, for the exhaustion argument, it would be interesting to find out what technology was licensed by InterDigital from Qualcomm. This is relevant for the argument, for example, whether the patents read on the handset or on the chipset. And regarding the front assessment, there would be also interesting to see what elements were covered, if there was an overlap in the technology. For example, if this agreement between InterDigital and Qualcomm, what standards did it cover? Did it cover also 3G, which was partly relevant here as well? So here the court did not have many doubts that this agreement between InterDigital and Qualcomm would be useful for deciding the case. So it ordered that this should be disclosed. Then should Oppo disclose its agreement with Qualcomm? And the answer was yes again here. The court looked at the situation and basically said that there is no reason why Oppo's should not be included here in the proceedings, especially if you look at the exhaustion argument. Here, this is of course the main element. Oppo had based its argument on the fact that it buys the chipsets from Qualcomm and that the chipset were licensed by Qualcomm. And here, that's why this agreement was seen as quite relevant by the court for assessing what Oppo has licensed from Qualcomm, the nature of the technology again, so where do the patents read, and also interestingly, whether Qualcomm has made any representation to Oppo that the chipset were licensed by InterDigital and they could basically license them for sell them licensed and covering also the rights that InterDigital has. So this was pretty clear also in the eyes of the court that this was relevant and necessary for the proceedings here, for the argument of exhaustion particularly. And then finally, the court was asked to decide whether Oppo should disclose also its agreements with Ericsson and Orange. And here the court said no, this should not be the case, and refused to order disclosure of these agreements. Why? The main reason was that the court found that these agreements with third parties cannot have a bearing, at least at this stage of the proceedings, to the rates offered by the plaintiffs to their licensees. So here basically the court said what you do here in InterDigital is to require basically that Oppo takes a license on the terms that you claim to be front and that other licensees have also taken. That's why the focus should be on the comparable agreements of InterDigital. So agreements that InterDigital has signed with other licensees or agreements of other SEP owners, and not of the agreements that the potential licensee Oppo has signed here with other patent owners. So that's why at least at this stage of the proceedings, there was no necessity in the eyes of the court to dig deeper into the agreements that Oppo has signed with other SEP owners. More relevant or most relevant would be here comparable licenses that InterDigital has signed with others. And having said that, the court also said here that InterDigital did not also show any specific reasons why these specific two agreements should be particularly relevant and should be disclosed here. So that's why the court refused to order disclosure. Finally, here, although not directly but indirectly, I think the court also placed some importance on the fact that the confidentiality and interests of the licensors, Ericsson and Orange, should be taken into account here as well, by saying that the protection of third-party confidentiality is a factor which also appeals to the High Court in this context. So again, something that would advocate for not granting access to these agreements to InterDigital, at least at this stage of the proceedings.